And keeping in what we say in tandem, we thought let's have a session on this, the panel discussion on maintaining the rule of law in times of national security crisis. And amongst us, we am welcoming on behalf of Beyond Law CLC, the Mississippi College School of Law, Jackson, Mississippi, USA. And we have come together today with a very unique panel discussion, which is in collaboration with the MC School of Law and Beyond Law CLC. As I'd earlier told you that the topic and discussion is maintaining the rule of law in times of national security crisis. And as we all know that every country has its unique security situation. Different nations deal with different situations differently. It's always a challenge to maintain the rule of law. And as we have been connected, at least I and Navdeep with Shruti Bedi, she speaks a lot on rule of law of them, and rest because of the book, I know that a lot they also discuss about that issue. And today's discussions would be on the situation, the challenges, the solution and balance, how to maintain them. And the book, which is already doing very well, that is The March to Justice, Global Military Law Landmarks. That is Professor Franklin Rosenblatt of the MC School of Law and Judge, Military Court of Appeals. And Major Navdeep Singh, advocate, Punjab and Haryana High Court, who is also a dear friend of mine, would be moderating the discussions, who I can say, though it is on the virtual platform with what we say moderate, there we say editors, who had edited that book in a different way. And all participants today are the contributors of the essay to the books by Franklin and Navdeep. And those who wanted, I can just show the book, that is The March to Justice, of what we had the book launch. We all actually are thoroughly enjoying that book. I was telling to Navdeep that, in fact, I've been glued to this book so much. And now I will introduce the special panel discussants. That is Professor Shruti Bedi. Professor Bedi is a professor of law at the University Institute of Legal Studies, what we shortly call as ULS, Punjab University, Chandigarh, India. She herself is an author and has written many books on law, and in fact, she has also is a TEDx speaker, plus she has also shared her knowledge on the platform of Beyond Law CLC. In fact, I can say that the seedlings of Beyond Law CLC, she had a major role in that contribution, and Navdeep has also been one of the contributors in the growth of Beyond Law CLC channel. And Frank also, I can say, because the book launch was there, and the others also we had connected. Ms. Nino Nicola Shivli is the head of the department representing Georgia before all international courts and teaches 2 universities in Georgia. And Dr. Katrina Busul is a lawyer and also teaches the National University at Ukraine. Mr. Kiran Mohandas Menon is a scholar at the Irsh Center for Human Rights, Ireland, and has been associated with many outstanding international academics and legal organizations. I can just say that it's a galaxy where we all have speakers of immense knowledge. And sometimes you feel once you are in the galaxy of such people, probably you are the odd man out. And it's also, as I say, it's always the cherry on the top of the cake that we have Professor Christopher Henkel of the MC School of Law. Professor Henkel is an expert of international law, commercial law, business law, and European law, just to name the few fields. Since there are too many panelists and we have the editors where we have a lot to learn, exchange ideas. And as they say that once you start exchanging ideas, there's a better growth. And what we say that from I to we is the difference is that I is illness and we is wellness when we talk of the COVID times. So I can only say that once you read this book and after these discussions, your mindsets at how the rule of law changes and what are the common platforms for all the different countries and the world across, and what are the challenges which everyone faces. Without taking much time, I would request Navdeep and Franklin to take over the baton. As they say in the relay race, you have to hand over the baton to the best player who can take things forward. Over to you.
Thank you, Mr. Chatrath. As you rightly said, that there's so much to learn from each other, and within the nation, and even, of course, globally. And we are in a global setting right now. And there's so much common ground too. It's not that all these issues are unique to specific nations, but apart from there being a lot to learn from each other, there's common ground, and the principles of law are mostly the same in modern society with respect to human rights and respect to the rule of law. So it's a very nice idea to hold a discussion on this topic, and the credit goes to Frank. And we have divided the moderation into two parts, wherein I'll be speaking to two panel discussants, and then followed by the rest two by my brother Frank. So we are going to start off with Dr. Shruti Bedi.
Just a minute, Navdeep. I just forgot that those who are watching us live on the Facebook and YouTube, they can post their questions. The panelists will be too happy to share with their ideas and thoughts. Over to you.
Yes, in fact, I've already received a few questions on Twitter and on my personal WhatsApp. So we will be having a short question and answer session at the end. We'll keep it very brief, and we'll keep it a bit breezy, not too heavy. And of course, everybody speaks in their own personal capacities, and it's the idea is not to take a particular side. We are going to be very objective and non-controversial in that sense. The idea is to share thoughts towards a better tomorrow. So let's start with Dr. Bedi. Dr. Bedi, this is, I'll start directly with the spirit of the chapter that you've contributed to our book, March to Justice. And it's, as you say, it's an eternal question. How do you feel that human rights can be balanced out with security concerns of security forces in areas where there is, some kind of an internal strife or some kind of a security situation? And how can we deal with such security aspects efficiently without compromising on human rights?
Thank you so much, Navdeep. I would like to take this opportunity initially to thank everyone for hosting me, Mr. Vikas Chatrath, and for organizing it, both Frank and Navdeep, and for my fellow panelists. It's a pleasure to be here. This question, like you said, is the eternal question. And I think the answer to this is not straightforward, because like always, we feel that security on the one hand and the rights on the other hand, it's like oil and water. They just don't mix. But the point that we must understand is that what is the situation which is prevailing at the moment in the territory which you are referring to would be a cause for concern. So if the situation is something which demands a higher security from the government, from the forces, then our perspective would be slightly tilted in favor of the forces who have been called upon to provide the security to the people, to the citizens of that area. But if you're talking of normal times, in a situation where there's peace, so in that situation, I think it is comfortable to, especially in a democracy, to highlight the rights of the people. But regardless of that, in times of war or in times of domestic insurgency problems, when the armed forces are dealing with situations wherein it is the mandatory duty of these forces to provide protection to the civilians, to the civil society, unfortunately, there does arise a conflict when, in the pursuit of providing security, they come into conflict because of the situation which arises where there is an impact, a negative impact on the rights of the very people who they are trying to protect. And it is here very important for us as a democracy to understand that rule of law cannot be forgotten. How do we treat other people? How do we feel about the other people? And that is what we talk about when we talk about rights. That is the rights that we are speaking of. And this is the very aspect that the enemy wants us to forget, of which they are bereft of, because they do not follow the concept of rule of law. They do not follow the concept of the protection of rights and liberties. So if they succeed in ensuring that we also forget about the rights in our pursuit of providing security to the people, they have won the war, so to say. And it is this very point that we need to understand, that we must be able to, in our effort to provide security to the people, must not forget that the rights are equally important. And it is here that the democratic institutions, because the role does not always fall upon the forces, it is the institutions which are engaged in ensuring the rule of law, which must equally come together and work towards providing such a state. So I think this is what we are trying to strive towards. And if we are able to succeed somewhat initially and maybe more as time goes by, our purpose would be served. Because we have to distinguish between authoritarian regimes and a democracy. And in a democracy, it is the rights of the people where we give equal importance to those as compared to a different regime.
I absolutely cannot disagree with that. And it also reminds me that, for example, the current Indian Army chief, he has re-emphasized time and again that India is a nation which is governed by the rule of law, and the protection of the human rights and maintaining and retaining the concept of rule of law is very, very important to us. Of course, there are aberrations. Aberrations do happen, as it's a human failing, and those aberrations must be taken through the processes of law. And but also, from what you're saying, it comes to my mind that I don't even think that people are aware on both sides of the debate that even the protection currently granted, for example, under the Armed Forces Special Powers Act, the protection is only granted to good faith actions and in the course of performance of duties. So members of the forces as well as other citizens must be clear that bad faith actions or intentional transgression of law will not be tolerated. It will not be tolerated in the army, as the army chief says. It will not be tolerated in any democracy, for that matter, not just India. And it is not that somebody goes in with a bad intention and carries out a crime, and he or she will be protected in the name of national security. So that aspect must be very clear in the minds of people, and this misconception must go. And as you've written also, in your chapter, you've spoken of the 10 commandments of the Indian Army. For example, I'm just specifying Indian Army, although it's a global discussion because of your chapter, because that specifically deals with the Indian Army and those 10 commandments that we must follow. I totally appreciate that there are no clear answers to this. That rule of law has to prevail, that human rights must be protected is non-negotiable. It's a non-negotiable aspect. But there are no clear-cut answers sometimes in the gray battle zones or in the kind of conflict that we see in these areas and regions, especially internal strife, where there's not where we are not seeing a conventional war, with infantry and the armored facing each other. But it's a totally gray battle, and sometimes in urban area. And so, you have any? In your mind, do you have any concept that can be enforced to ensure that the rule of law is maintained in such gray battle zones, and also any particular manner to protect troops and members of forces from vexatious litigation if it so arises? I'm not looking for a straight cut answer from you, but in your mind, can you think of any such aspect or any such answer to these issues?
Thank you, Navdeep. I think that's a very pertinent point that you have raised. In my chapter for your book on March to Justice, I have dealt with the Indian case of the Manipur encounters, where the Supreme Court of India has actually, like you said, clearly stated that there is no blanket immunity available to the soldiers. So even if they are doing their job, they're going about their duty, it does not give them a blanket immunity from any kind of investigation into an offense that they would have committed during the course of their performance of their duty. And as you have said also, that the action of the soldier will be analyzed on the touchstone of the phrase whether he has committed that act in good faith. So that is a very important foil for the analysis that we are talking of here. And like any democracy, the soldier does face a trial before the, we have an option in India, whether it is going to be held before the military court or the ordinary courts. And that is something which is decided on the basis of the grievousness of the offense, and of course, the intervention of the courts as well. And if the soldier is to be tried, the sanction has to be taken from the required authorities. But the point being that a proper procedure will be followed, an investigation into the crimes is to be made out, and the trial will take effect. And if the soldier is found guilty, he will be punished. So there is no immunity that is provided. That is the first question that I think you were speaking of. And I mean, there are times when, you know, people from the civil society do feel that the soldiers have sort of an advantage over them. But here I just want to highlight that, in fact, the soldiers would probably have a disadvantage because, you know, they have been called upon to carry out a task which is not palatable, in the sense that they are trying to protect the civilians. And in the process, there could be situations where they do end up overstepping the authority which has been granted to them and or the mandate of the job. However, if that action of the soldier is carried out in bad faith, then the responsibility is his to bear, and he will undergo the punishment for his crime that he has committed. So regardless of opinions, this is the law. And the second point, which actually speaks of the protection for the soldier from vexatious litigation. I think here it is important for us as a democracy, again, to strengthen institutions like the courts, which not only include the judges, but the prosecutor or the lawyers and advocates who are dealing with the matters. I think they should be trained well. The investigation needs to be carried out properly. And of course, if there is, if the judge feels that it is vexatious, he has to put a stop with, I personally feel probably impose a kind of a penalty on it being vexatious in nature. So I think that would provide something of a stop to any people who want to target the forces for unnecessarily and highlight something which is, which could be brushed under the carpet. So it is in that sense that the courts, the judiciary, along with that, the lawmakers, because the laws, the legislations should be drafted in a way which is careful to ensure this protection to the forces who are carrying out a responsibility which is not an easy task in any way. So both the legislation and the institutions of a democracy need to be far more vigilant of their own responsibilities in ensuring that we are able to balance the rights, implement the rule of law, even during emergencies, even during times of war or insurgency or strife or conflict.
Yes, I very, very well stated. And in fact, we are lucky to be living in a democracy, and especially in common law countries, because nothing is immune from judicial review. And so any party which is not satisfied with the action of the state or even a soldier who may not be satisfied against prosecution launched against him or her. Everybody has the right to approach courts for judicial redress. And in fact, judicial review remains one of the most precious rights in democracies. No doubt on that. And so, as also you concluded in the chapter, that no court and no law can provide the perfect answer, but we have a general answer, and we have a general idea on, and hopefully one day the human rights of the citizens and human rights of even human rights of soldiers who are performing those duties are equally protected, and they're at an equal pious pedestal. Thank you, Dr. Bedi, for a very kind and nice exposition of the topic. And of course, if there are questions and answers, we are going to get back to you on that. So now I'm going to go on to Miss Nino Nikolashvili, and I'm thankful to her because she had some office engagements, and she's holding a very responsible office, but she could squeeze out some time for us, and it's great to have her here. And she's also contributed to our book. And without wasting any further time, I would like to ask you the very important decision in which of the European Court of Human Rights, in which you also played a major role, Georgia versus Russia 2. Kindly tell us about this historic victory in this case, and tell us more about the implication. Just give us a very brief background and tell us more about the implication of this decision on the national security issues concerning your region, please.
Well, thank you once again. I'm very excited to be here today, and also thanks to my great friends, Frank and Navdeep, for giving me a possibility to contribute to your excellent book, March to Justice, in which also my article is included. Thank you for a very interesting question. Let me start with a very brief overview regarding Georgia. As you are all very well aware, it has very important geopolitical location, which is situated at a strategically important crossroads. And Georgia's stated goal, of course, is to become a full member of the European and Euro-Atlantic structures, which is also envisaged by its constitution, reflects the will of the society. And as you are all very well aware, Georgia was one of the first Soviet republics to take steps towards independence. And it has been the victim of the Russia's aggression throughout its history. And in order to infringe upon its sovereignty and territorial integrity, in August 2008, the Russian Federation perpetrated a further military aggression, accompanied by a new wave of ethnic cleansing. And unfortunately, today, 20% of the territories of Georgia is occupied by Russia. After all these events, the only means which Georgia used, this was the legal mean, and this was the international legal order in order to restore justice and in order to restore the rights which were violated by Russian Federation. So Georgia applied and referred to all international legal means, but today I would draw your attention to the International Criminal Court, which on the one hand includes the individual responsibility for the heinous crimes committed against ethnic Georgians, and as well as to draw your attention to the state responsibility. And in that regard, of course, the European Court of Human Rights, the Strasbourg Court mentioned by you, plays a paramount role. Let me start with the ICC, with the International Criminal Court, which investigates the crimes against humanity and the war crimes which were committed in the context of an international armed conflict in 2008 in and around Trinwali region. Also, for now, there are no results of the investigation, but we do hope that quite shortly the ICC will publish its results of the present investigation. As for the Strasbourg court mentioned by you, rightly emphasized by you, last year, in January last year, Georgia achieved a historic victory over Russia in the case of Georgia versus Russia 2, which concerns the August 2008 events. And this was a really historical judgment, as it represents the first legal document rendered by such prestigious court as it is the Strasbourg court. And the judgment directly notes that Russia was responsible for the mass violations committed against the Georgian population as it exercised effective control over the Singh Valley region and Abkhazia. The court also upheld Georgians' claim that the aforementioned territories, of course, represent an integral part of Georgia and they are occupied by Russia. And also the European Court confirmed that these violations carried out by Russia amounted to ethnic cleansing of Georgians during the 2008 August war. Apart from this case, let me also mention that in 2018, Georgia also lodged another interstate case before the European Court against Russian Federation. And this complaint, which is currently pending before the court, and which is resumed. It concerns the administrative practice of harassment, arrests, assaults, and killings of the Georgian citizens in the Russian-occupied territories of Georgia. And these actions intensified, especially after the 2008 war, and we do hope that the government of Georgia will effectively protect the interests of the state in the above-mentioned ongoing interstate dispute as well. Therefore, to sum up, Georgia really, we can name Georgia as a role model, a small country which aims to restore justice and to bring justice to the victims solely by peaceful means and solely by international legal means. As for your question as what would be the impact of the historical judgment of the Georgia versus Russia 2, of course, we should emphasize that once the judgment is rendered, it does not mean that the justice is restored, as the justice is only restored when the judgment is enforced, right? Therefore, enforcement of this interstate judgment is also a very complex process. It involves individual as well as general measures. As you are all well aware, the European Court's judgments are monitored to be enforced by the Council of Europe, by the Committee of Ministers of the Council of Europe, which monitors the enforcement of the judgment, of course, including the interstate judgment of Georgia versus Russia 2. And the impacts, of course, we can divide these impacts into two groups, right? So it would be the individual measures, such as the just satisfaction for the victims of the heinous crimes, as well as investigation by the respondent state of the crimes which were committed during the August war. And also enforcement involves, apart from the aforementioned individual measures, it also involves general measures, right? Which is a very complex process, but we do hope that as a general measure, this judgment should ensure the safe return of all internally displaced persons to their homes throughout Georgia, including in Abkhazia and Singh Valley region. And of course, one of the main aims which this judgment should have in a very large picture, of course, it should be the occupation of the country, because as I already mentioned, unfortunately, 20% of our territories are occupied. So we do hope that this historical legal peace will have a very important impact on the occupation of our country.
Thanks a lot. That was a pretty unique aspect of the issue that you have thrown light upon. And in fact, I was not very clear, speaking for myself, on how the judgments of ECHR the European Court are implemented, and what are the teeth that they have to implement such or execute their dicta. thank you for throwing light on that. And most of all, let us hope that peace prevails. I mean, there would be no reason for us to delve into these issues if we had a peaceful society and equanimity and calmness in our societies. And let's hope for that ultimate aim. Nino, can you also, although it's not directly linked, but can you also give a very short, in a few minutes, 2-3 minutes, a gist of the chapter that you have written for our book? Because that's also a very interesting judgment by your constitutional court. So just for the other viewers and for the other panel discussants, just a short snapshot of what that judgment was.
Yes, of course. Thank you. My chapter in the book of March to Justice concerns the concept of conscientious objection to military service, including the judgment of Constitutional Court of Georgia. Well, the chapter initially provides brief overview regarding Georgia, its geopolitical location, threats, ongoing occupation, and international disputes. After this introduction, the chapter thoroughly analyzes the concept of conscientious objection. As you are all very well aware, there is no clear norm regarding it in international human rights law, but the authoritative bodies such as the UN Human Rights Committee, such as the Strasbourg Court, etc., in their case law and in their other documents, have indicated that, for instance, the Article 18 of the ICCPR and Article 9 of the European Convention, which envisages right to belief, conscience, and religion, by itself involves right to conscientious objection, which means that the person can refuse, for instance, to serve in a military service due to his or her conscience and religious reasons, right? So the chapter analyzes all the international documents as the case law in international human rights law. And after that, it shifts to the judgment of the Constitutional Court of Georgia, which has declared the normative content of the Georgian domestic legislation unconstitutional, which did not allow the persons to refuse military service on the grounds of the conscientious objection. So the chapter goes into deep analysis of the Constitutional Court's judgment, which is in line with the standards of the UN Human Rights Committee, of the Strasbourg Court, etc. And just to be very quick and to sum up, the main idea after all this analysis and the main finding of this chapter is that it is crystal clear that states must universally ensure the right to object to military service based on genuinely held religious beliefs as an integral part of the absolute right to hold beliefs. And also one of the main findings of the chapter is that compliance of national legislation and case law of the highest domestic courts, for instance, in the case of Georgia, the findings of the Constitutional Court, with international human rights standards will further decrease complaints lodged before international regional human rights bodies and ensure universal protection of human rights worldwide. Thank you.
I don't know whether other panel discussants or our viewers are aware of the movie Hacksaw Ridge on conscientious objection. It's a story of it's a true story of Desmond Doss, who was a soldier in the US Army, who refused to bear arms because of his religious beliefs, and yet because of his utmost bravery, he was awarded and decorated with the Congressional Medal of Honor. It's a good movie. I mean, if you get the time, you must watch that movie. Hacksaw Ridge, it is called. Especially you, Nino, you must watch it. It goes well with gels well with your chapter. Thanks a lot. And we'll get back to you for questions. Franklin, over to you, my brother.
Hey, thanks, Navdeep. And good morning, everyone, from the Mississippi College School of Law in Jackson, Mississippi. I'm first going to ask questions to Dr. Katerina Busol. Dr. Busol is an expert in many forms of law that start with international. That would be international human rights law, international criminal law, and of course, the law that applies in armed conflict, international humanitarian law. So being an international law expert, Dr. Busal, in her chapter for March to Justice, looked inward to her home country, Ukraine, a country that all of the world is watching today. So Dr. Busal, you wrote about a 2001 Constitutional Court decision from Ukraine, and you started your chapter by quoting Shakespeare, past his prologue. So over to you. Tell us about this decision and what it's like as an international lawyer looking inward at your home country.
Thank you very much, dear Frank, and it's such a pleasure to be with all of you, both in the book and in this presentation. And indeed, I wish, to be honest, the attention of the world to my country as of now was for another reason, but it actually represents this quote, what's past this prologue, very well, because it also connects us to the issue of historical legacy of Russia's imperial encroachment on the countries like Ukraine or Georgia, and effectively its willingness to prevent any further European or Euro-Atlantic integration of the former Soviet republics, Georgia and Ukraine. And what happened in 2001, that the year when the Constitutional Court of Ukraine adopted its notorious judgment on the compliance of the Rome Statute with Ukraine's constitution, one would never think would be relevant more than a decade later, when the country actually became affected by the aggression of its neighbor and became involved in an international armed conflict, having parts of its territory occupied, namely the Crimean Peninsula and the eastern parts of Ukraine. So in 2001, the Constitutional Court of Ukraine decided that the Rome Statute of the International Criminal Court provided for this additional jurisdiction that basically did not fit well with the Ukrainian constitution. So the court misread the concept of complementarity, which, as we know, is foundational to the ICC structure, and interpreted it in a way that it could not provide for any additional courts to join the Ukrainian judicial system unless this is provided in the constitution. So the court did not understand that the ICC steps in only when a national state cannot investigate or prosecute domestically or is unwilling to do so, and more importantly, that this principal right to investigate and prosecute the gravest crimes remain with national states. And that would remain an issue only for, a handful of Ukrainian international lawyers and academics who write in this field, again, unless the armed conflict in 2014 had not erupted. And when that started, Ukraine pursued the same strategy as described by Nino that Georgia has pursued, namely that it referred to all available international courts to adjudicate the different aspects of Russian aggression. And of course, the International Criminal Court that can pronounce on the individual criminal responsibility for war crimes and crimes against humanity was also on Ukraine's list. But then the question, law and policy-wise, domestically in the country, was how do you approach the court, whose statute, you said, did not really comply with your domestic law? So luckily, the amendments to the constitution have been made, so it's now expressly recognized that Ukraine may recognize the jurisdiction of the court under the Rome Statute. And more importantly, Ukraine has recognized the jurisdiction of the ICC in an ad hoc way, specifically for the situation of the Russian aggression. The problem remains, and I would say this is a big political domestic problem, that the country still refuses to ratify the Rome Statute. And unfortunately, there are many internal political indicators that should the ICC decide to proceed with arrest warrants, which certain political figures in Ukraine don't like, the country might refuse to cooperate with the court, which of course will be devastating for the country's reputation. But we understand that under international law, it will not prevent the ICC from intervening. So I would say this dichotomy unfortunately remains. It speaks about the larger issue of the lack of understanding of international law by many of Ukrainian legal professionals, apart from certain people who did practice international law or did write about it academically. But we are also hoping to learn more from Georgia, because Georgia has been very proactive with the ICC rather than reactive. And same was with the reform of the domestic legislation. So Georgia exemplary did implement domestically the Rome Statute crimes actually before the armed conflict with Russia started, whereas Ukraine is doing it basically retroactively after the occupation of the parts of the country continued. So I'm hoping that the two lessons that the country will learn from that will be, A, that of course the Rome Statute should be ratified and the full cooperation with the ICC should be pursued, most importantly for the interests of the survivors of the grave war crimes and crimes against humanity perpetrated in the context of the Russia-Ukraine armed conflict. And preliminary, the prosecutor of the ICC has named such crimes as sham trials, torture, enforced disappearance, rape and other forms of sexual violence. So unfortunately, both the scope and the gravity is staggering. And the second point, I'm really hoping that the country will move from this reactive rather to proactive policy making and will work on the implementation of IHL, international humanitarian law, preemptively in peacetime, will work more on the gendered understanding of policy making and conflict resolution more proactively as well. And again, in this regard, Georgia has been a great example for us. Thank you very much.
Well, thank you, Dr. Büsel. That's a great point. You're in a country that's now in national security crisis, where passions are flared, where institutions are under pressure, and where politics plays a greater role. What advice in 2 or 3 minutes would you have for other countries that aren't yet at a point of national security crisis? What can they do now when they have the possibility of shaping their laws and institutions?
I think it's the point that I made before, to be more preemptive and proactive rather than reactive post factum after the grave violations have been perpetrated. Also, it's a real, not just illegal, but human experience that I now see how important the participation of women and really of the different strata of the society, the equal participation of the whole spectrum of the country's talent is needed to building the domestic policies, because we can see how the lack of, how the silences about particular crimes such as sexual violence is affecting both sexes, and how it is up to the female survivors who are bringing it, to the surface, who are trying to persuade both female and male survivors to speak about these policies more. So this has been very impactful. And I think another lesson which actually I think distinguishes Ukraine from Georgia, and which has been a very positive development given the Soviet, post-Soviet context, is the cooperation between the civil society and the government. It has been unparalleled in terms of the documentation of alleged war crimes and crimes against humanity, in terms of drafting communications to the ICC, and in terms of drafting different initiatives related to the country's unfolding transitional justice policy. So this merger, this productive merger of the civil society and policymakers, I think is something which could be very productive and very solid for the society, both in times of peace and in times of the national security disturbances.
That's absolutely fascinating, Dr. Büsel. I think there will be a lot of interest in the Q&A should we get so far. I'll turn briefly now to Kiran Mohandas Menon, a friend of mine who's been an international law activist and an activist for international criminal law in particular in Greece, Spain, India, Germany, and now he found himself in Ireland, where he's pursuing his PhD. So, Kieran, you're in Ireland right now, but you wrote about a 1991 case, Polukovich, in Australia. A fascinating, interesting case. Could you start by telling us a little bit about that?
Thank you. Firstly, let me just start by saying thank you to both of you, Frank and Navdeep, for well, the extraordinary effort you've put in compiling this volume and bringing together such distinguished and diverse voices from across the world. And also thanks to the organizers and my co-panelists. I've definitely been enjoying the discussion so far. So I think to answer your question, it might be important to look at why Polukovich as a case. I think when we look at the story of international criminal justice, we sometimes seem to ignore the extraordinary developments that have quietly accumulated in domestic jurisdictions. I think they lie waiting for their moment there before some major tragic cataclysmic event leads to them being incorporated into more international narratives. This is not to make blanket statements and say that Polukovich was an extraordinary pioneer, or that it's well served to become a parable of this reality. But I think at a time such as now, when there is substantial increase in domestic jurisdictions, either prosecuting international crimes or empowering themselves to do so, there is value in reflecting on some of these cases that can still serve as a sort of signpost in the road that international criminal justice is supposed to tread on. So that's what I meant when I wrote that Polukovich, in a sense, still remains timely, relevant, and contentious. This is a case that starts with the High Court of Australia hearing an appeal to the War Crimes Amendment Act of 1988. That act was aimed at criminalizing certain actions that had occurred during the Second World War, after reports came in that quite a lot of people may have actually fled to Australia and may have been living in Australian towns and cities, having committed crimes during the Second World War, and well, living in impunity. Now, it became a case that I think went further than the confines of the facts that it was dealing with in terms of its legacy. It became a case that looked as sort of assessed how the Commonwealth of Australia viewed itself and the powers of its legislature, of its external affairs ministries. And I don't want to go into the technical discussions or judicial discordances that were reflected in the case too much, unless you would like me to, because I think anyone interested in that can find that, of course, both in the judgment and as well as in your brilliant volume. But I think what we can look at in terms of Polukovich, and a personal interest I have, is because Polukovich was one of the cases that evoked universal jurisdiction way before the Pinochet judgment, and the trajectory of how courts viewed that doctrine became a norm. So in that sense, I'd like to point out a memorable extract from the case, if I could, that deals with universal jurisdiction themes, courtesy of Justice Brennan, who states that Australia's international personality would be incomplete if it were unable to exercise a jurisdiction to try and punish offenders against the law of nations whose crimes are such that their subjection to universal values is conducive to international peace. And we need to remember that this was, again, written in 1990. 2 years later, as the Gulf War raged on, Benjamin Ferencz, I'm sure many of you will know, the chief prosecutor of the Einsatzgruppen trial, one of the subsequent Nuremberg trials, wrote an article in which he has this poignant sort of extract where he says, of course, international laws, if they are to have meaning, must be clear and must be respected universally. It is not enough merely to pay lip service to the principles and precedents of Nuremberg. The ideals therein enshrined must become a living reality in a peaceful world. Hypocrisy must give way to sincerity. Politics must yield to principle. Lawlessness must be controlled by the law. So I think this is the context that cases like Polukovich have served, in that it is important to look at unorthodox or unexpected routes that has been traversed by international criminal justice in this area, going beyond, the usual confines of international courts. And this is where universal jurisdiction can come into play. It can look at how states have engaged with international criminal justice and the progressions and regressions that you see in that sense, as well as the historical responsibility in scenarios which have warranted international criminal justice interventions, but where a combination of factors, usually political, have prevented such accountability. So I hope I answered your question and didn't go on a tangent there.
That's fascinating, Kieran. And, you're writing about something that is, the revolution that's sweeping many countries right now, the universal jurisdiction. And so that's one side of the coin. Is a country able to? And give us your thoughts on the other side of the coin. Is a country willing? Because I don't think that Australia would be unique in its desire to at least a reluctance to hold its own citizens accountable for atrocities that they may have committed. We seem to see this all over the world. So tell us your thoughts on domestic jurisdictions and the willingness or even the self-interest of countries to hold their own citizens accountable.
Well, first of all, I think there is still a reluctance to accept that outward or inward institutional reflections in these contexts is not a sign of weakness, but that it is a sign of strength. I think that's what Robert Jackson meant when, in that opening statement in Nuremberg, he stated that even if uncomfortable realities were being unveiled, that this was one of the great tributes that power was giving to reason. Australia is, unfortunately, as you know, I'm sure you might know, the Inspector General of the Australian Defence Forces in Afghanistan recently released a report. It was called the Brereton Report, and it was a report into the war crimes that were allegedly committed by the Australian Defence Forces during the war in Afghanistan, particularly between 2005 and 2016. That investigation was led by Paul Brereton, who was a New South Wales Supreme Court judge, as well as a Major General in the Army Reserves. And it found credible information that implicated 25 serving or former Australian soldiers in the alleged unlawful killing of 39 people in Afghanistan. And crucially recommended that the Australian government provide redress to the families of victims without waiting for prosecutions to conclude. Unfortunately, that hasn't still come into fruition. When this happened, the Australian Defence Chief, while presenting the report, stated that some patrols took law into their own hands, rules were broken, stories concocted, lies told, prisoners killed, and once that rules were broken, so too was further restraint. Now, there's an Office of Special Investigations that has been established 2 years ago. But as you can imagine, with the changing situation in Afghanistan, that office has been struggling to conduct its investigations. It is envisaged that in 5 or 6 years, it might take up to 5 or 6 years before we get any concrete results as to their investigations. The government has set up a separate oversight panel that will exist to ensure that the defense forces do not sort of stray from the broader response to the inquiry's findings. But I think, as you said, Frank, this is definitely a moment that will be judged in terms of Australia's response and the wider response of states that have been allied with Australia with regards to what happened in Afghanistan. So I think we'll have to wait and see if it will lead to some sort of a potential domino effect on accountability efforts in that context, although I wouldn't be keeping my fingers crossed.
Well, Kieran, thank you for those trenchant insights. But for now, I'm going to turn it back to Navdeep and the organizers. I imagine that around the world, this conference is being live streamed in large football stadiums and cricket stadiums, and many of those viewers may have submitted questions in the Q&A.
Yes, I have some questions, and interestingly, Frank, the first question is for you. not for the other panel discussants, and it was on Twitter by Group Captain LP Joshi. He is asked that how do military in the context of the United States and the US military, how do military leaders decide between constitutional duty and executive directions? Perhaps he means that how do military leaders decide between their legal duties and executive directions if they're in conflict with what is legally permissible?
Well, a lot of that starts with the civics training that we give to officers. There's been, in the I think the tumultuous and abrupt transition from the Trump to Biden administration, you saw a lot of conflicts between what is the officer's constitutional duty among senior Pentagon officials, and especially the decisions of General Mark Milley responding to some turmoil in Washington, D.C. And that's led to emphasis on, what do we do next and how we train. Some of that has been with the military lawyers and the judge advocates who play more of a role in military affairs than ever was there in the past. But I don't think that the JAGs are going to be able to parse out and have every answer for constitutional versus what's right and what's the duty. That's going to come down to back to something that Katarina talked about. The involvement, does the military represent all of our society? Does it include members from all walks? Is it women and men? Are we advancing racial and ethnic minorities and others who have been underrepresented in the past to senior leadership? And that combined with the civics in our education of the officer corps and really all military members, I think without looking at any one instance, that's going to be how we can do the best we can to have a truly professional military force responsive to the nation's needs.
Great. And there's another question for Dr. Bedi, but I think she has already answered it. How should law be tightened to ensure protection by Ankit? How should law be tightened to ensure protection of human rights of citizens residing in an area as well as protection of human rights of soldiers? But I think Dr. Bedi, you have answered it in a very detailed manner. So perhaps we can, go on to the next one because you explained it very nicely. So Ankit, if you're hearing this, you already have your answer now because we discussed this very aspect. Katrina, there's a question from my son, Saurabh Singh. He follows your region very closely, and he did not want to make it very controversial, so he has toned it down, and perhaps he'll ask you one-to-one later. But he says that in case of any conflict, though let's not hope there is a conflict at all, are the territorial defense brigades in the country, in Ukraine, aware and trained to comply with the Geneva Convention? And he asks, are there any concerns over units such as the Azov Battalion?
Thank you very much. And your son is so well informed, knowing the names of the specific battalions. Thanks a lot for being so informed. First, as regards whether the conflict happens or not, the conflict is already there and has been since 2014. I want to stress that, and that's not just Ukraine's position, that was confirmed, including by the International Criminal Court and many international organizations as well. As regards the IHL training, I think this is one of the most poignant issues remaining, because I have been involved in training the Ukrainian military throughout these years. They do have, of course, the military manual that did provide for certain IHL training, but to be honest, nobody in the country expected to be in a situation where that knowledge would be applicable and needed in practice. So, of course, much update has been provided to the actual military, and many so-called voluntary battalions, as you might know, that supported the activities of the actual armed forces at the beginning of the armed conflict in 2014 and 15, they have been integrated into the armed forces. So then the trainings were joined and ongoing. As regards the territorial defense, this is something, to be honest, quite new for the country, and it is expanding and growing now, understandably, in the face of the the growing threat from Russia and the another possible invasion. I think I don't know. I would just be very honest. I don't know as to how they're being trained or prepared. I would presume that their training, of course, has not been as long-standing as it has been with the current members of the armed forces. But throughout this year, Ukraine's international partners, including the EU, have been so firm on underlying, the need to abide by the international law, and that need be valid for all the parties to the conflict, that I'm hoping that the government, in supporting the territorial defense units, also stresses that the compliance with international human rights and humanitarian law remains paramount. But as regards the details and the length of their actual training, it's just something that I'm not aware of, unfortunately.
Yeah,
but I'll be very happy to speak with your son separately.
We'll do that.
So that he would not have to tune down the tone of the question.
Yes, yes.
Thank you very
much.
And
in fact, it's very important for all forces, especially democracies, that every soldier must be aware of the basic IHL and basic law, human rights, the Geneva Convention. Every single soldier should be aware. That's what differentiates us from, just a ragtag militia. Organized armies must be well aware of these issues. And Katrina, another thing, the term Thunder Road in your chapter, was it from Bruce Springsteen?
Yes, of course. I'm a great lifelong fan.
Okay, so let us know the difference. A very pertinent question to this debate: the difference from glory days in 1984 to wasted days in 2021 with John Mellencamp. How was that journey? You don't have to answer that. You don't have to answer that. I'm just kidding.
I think this is the best webinar I have been to, honestly.
In fact, Frank and I, we've been invited to present a paper at a prestigious university on the impact of rock music on military justice.
Fantastic. I'm looking forward to watching the presentation and reading your paper.
But I'm kidding. I mean, as the late Meatloaf would say, that I would do anything for military justice, but I won't do that. So, but stay tuned. We might have we might have another panel discussion on this. No more questions with me, Frank and Mr. Chatrath. Can you check?
I have one question that's on the YouTube channel. Anil Chandra says, "Sir, ma'am, I request any of you to throw light on how to ground. The troops are taught, trained, and ingrained Geneva Convention, or do they at all?"
As for Indian Army, of course, yes, they do. I mean, it's especially officers are made to understand the Geneva Convention, and they're also told to disseminate the information amongst the troops. And I mean, Geneva Convention, or these are just basic human values and basic human rights. Even if I mean, in a modern democracy, the right and wrong must be very clear to troops. So yes, especially in the Indian Army, and I'm also aware in the US Army, they're very particular about this. Frank, and because only Frank and I have a military background here, I'm sure Frank can throw some light on.
Well, I would just add that my country, the United States, has not joined 174 other countries which have ratified the first and second additional protocols to the Geneva Convention. And that means for training and education, we spend more time talking about US policy. And this does create issues because we partner with our allies all over the world, and most of them are fully acceded to the Geneva Conventions.
I think, Navdeep, we don't have any other questions.
Great. So we'll request Professor Christoph Hankel to wrap up the discussion. And over to you, Professor.
Okay, I will do that. I did have a couple of questions, but in light of the hour, I'll just make some comments. And first of all, I want to thank everybody. I think this is a very timely and interesting topic. Not only because of India, Ukraine, or Georgia, which is often almost forgotten, and I mean the role of the two cases, at least two cases that Georgia had before the European Court of Human Rights, are quite interesting and might have triggered some of the responses from Russia to what we are discussing today, what Russia is trying to do with Ukraine. At the same time, it's very interesting in terms of the Ukraine to see how the rule of law will be applied in this context, and it's also quite timely in context of the case that involves Alexandra Repetillo, and how that will be proceeded further. In terms of conscientious objection, it might be interesting to look at the German example because there's a long history in context of the draft, and there are many cases that might be very informative. The enforcement of international law is, of course, always an issue, and what makes this discussion so timely is also the development of, or the push from human rights to more directly impact humanitarian law, and the conflict between both of them and the dividing lines there. And in terms of, I've been reminded, listening to all of you today, by the discussion of how international law is enforced, the judgments of the European Court of Human Rights also, and the question of outcasting and who is responsible for the enforcement of these laws. So it's very interesting, and I will discuss this with Frank a little bit more. Maybe we can in the future have a conference about this. It's because it's really so timely, and it's also timely. Let me just end with this and then wrap this up. Is because we have this conflict in the United States currently too. It's an undercurrent, but it's there, right? We are politicizing our Supreme Court, and President Biden just yesterday referred to the rule of law and how important it is to follow it when he pulled out the Constitution out of his pocket and referred to it in context of Justice Breyer retiring. So it's quite interesting and very timely. So I commend all of you, and I'm very happy that Frank was involved in this and that we kind of could play a role here. MC Law is a small private school in the South, and but we are very innovative, and we would be interested in working with all of you more closely together. And I say this also as the director of the International Comparative Law Center that we have. While my introduction earlier was focused a little bit on some of the things that I do on the side maybe, but my background is really, or the way I started out is in international law and in European Union law. And so I can very well relate to all of you. And I would look forward to working with all of you and maybe possibly bringing a conference to MC Law on this topic. So thank you, everybody. And this is a really exciting and timely topic. And I'm really happy that I could participate this morning and just listen into the discussion. And I hope we will see each other in the future again. Thank you.
Thank you, Professor. And we are also thankful, Frank and I are thankful to Mr. Vikas, Chatrath and MC Law for arranging this very unique panel discussion, and to all participants who took out time from their busy schedules to be here with us and discuss this very important issue. And let's hope that peace prevails and we don't have to discuss too much of conflict every time. And that's what we all strive for, especially in your regions, Nino and Katrina. Let's hope there is peace. Frank, would you like to say something before we wrap up?
Yeah, thanks a lot to Vikas, Christoph, Navdeep, Shruti, Katerina, Kiran, and Nini. I concur with Christoph. This is the start of something. Let's all get together again. There are more discussions to be had, and this was so topical today. So thank you.
Thank you.
So Navdeep, now we can wrap off. I can ask. We have been there with Shruti Bedi also. She can just pitch in. As they say that once we talk of rule of law, I would always say that it has to be with the rule of law. And where we have Shruti, then the best thing to wrap up comes from her. Over to you.
I think that's the best way to wrap up, Mr. Chatra. Thank you. But on the note that rule of law must prevail everywhere in the world. And that is what we strive towards. And let that be the talk for the future.
Yeah.
So thank you, everyone.
Before we part, inshallah, what we say in India. Yeah.
Thank you.
Thank you. Thank you.
Thank you so
Thank
much.
you
Thank you
all.
very much.
Thank you, everyone. Thank you.
Thank you. Wishing you all the best and peace.
Thank you.